Before we proceed to the second reading, if I would like to remind members, while I appreciate the familiarity and camaraderie that all of you share, do refrain from addressing fellow members by the first name, so do address each other a bit more formally. Order. The clerk will now proceed to read the orders of the day.
Item 2, Vulnerable Adults Bill, second reading.
Minister for Social and Family Development.
Mr. Speaker, I beg to move that the bill be now read a second time. With your permission, sir, may I ask the clerk to distribute an A4 copy of an infographic on the Vulnerable Adults Bill.
Please do.
Thank you. Sir, this bill seeks to protect individuals 18 years and older who cannot protect themselves from abuse, neglect, or self-neglect because of a mental or physical infirmity, disability, or incapacity. In the course of our work as members of Parliament, we would have come across households seeking help and assistance as they juggle the many roles expected of a family: breadwinner, caregiver to elderly parents, and parents to young or teenage children. It gets harder when elderly parents lose mental capacity because of dementia or become bedridden because of illness. Double the challenge if they have children with disability or special needs to provide for. Through various schemes and programs, we want to better enable our families as they carry out their caregiving roles as the first line of care and protection for the vulnerable members. Indeed, one of the key priorities for MSF and MOH, both now and in the years ahead, is to enhance support for the elderly and people with disability and special needs, and to better enable their family members and loved ones to carry out their roles as caregivers. From time to time, we hear sad cases where elderly persons or persons with disability or special needs are abused or neglected. Currently, we have in place a network of community and social service agencies which support families through social intervention such as counselling, case management, and case monitoring. Take the first case of Madam Chua, which is not her real name. We won't use any real names in this chamber on this topic. Madam Chua is a 68-year-old lady with early-stage dementia. When neighbours spotted Madam Chua wandering around the estate with bruises on her arms and around her left eye, they alerted the Family Service Centre. The FSC found out that Madam Chua's daughter would beat her mother every time Madam Chua soiled herself or left the stove on. When social workers contacted the daughter, she expressed remorse for using force against her mother. We found out that her daughter's anger stemmed from frustration and stress. Not only was she coping badly with her mother's failing health, she also needed to care for her own son who had special needs. The daughter agreed to participate in counselling and assistance programs to help her manage Madam Chua's failing mental and physical health. To provide the daughter with caregiver respite, the FSC also persuaded another of Madam Chua's daughters to step in to care for Madam Chua on weekdays. Assistance was also given to her to help her care for a son who has special needs. Since our involvement, there has not been further incidents of violence reported to date. Cases such as this remind us of the complexity of family relationships and the crucial role that family and community intervention plays in helping vulnerable individuals. But Singapore's population is rapidly aging. Today, more than 450,000 Singaporeans are aged 65 and above. In 12 years, by 2030, 1 in 4 will be 65 and above, and that is more than 900,000 elderly individuals. The number of residents living alone is also projected to increase to more than 80,000 in 2030. Our changing demographics impact our household structures, and this can complicate family dynamics. In our midst are vulnerable Singaporeans who may not be able to care for themselves as their physical or mental infirmities or disability. Some of these vulnerable individuals may not be able to depend on their families to provide adequate care for them. Others may not even have family members or friends to rely on. While our adult protection framework has functioned well, there are instances where family and community interventions may not be effective. Since MSF's Adult Protective Service, or APS, was established in 2015, the number of referrals to MSF has increased. On average, we handle about 110 cases annually involving vulnerable adults 18 years and above, though not all these cases eventually required our intervention. Our experience, validated by feedback from our stakeholders, indicates that family matters are never clear-cut, never black and white. Caregivers who abuse vulnerable adults may themselves be victims of difficult circumstances and be under tremendous stress. They are sometimes unable to control their emotions, which may cause them to hurt vulnerable adults or other family members. One of the cases where MSF had to intervene involves Sam, again not his real name. Sam is a 29-year-old young man with attention deficit hyperactivity disorder, or ADHD, autism, and an intellectual disability. Sam is an only child and lived with his elderly parents. However, his parents were not able to understand his condition and hence care for Sam. Sam's father would hit him to try to control his behavior. This resulted in severe cuts and bruises on Sam, all of which required medical attention. But Sam's behavior also caused his father a lot of stress. When MSF spoke with Sam's family members, they mentioned that Sam's father had entertained thoughts of killing his son and then ending his own life. Sam's father refused assistance and therapy for himself and his son, insisting that Sam be medicated to control his behavior. Given the high risk of Sam being hurt again, Sam was placed at a facility that was equipped to address his care needs. In cases like this, the government must take a proactive approach and intervene early, as any delays may lead to further harm or worse. Sir, I'm therefore putting the Vulnerable Adults Bill before this House, before members, to seek your support to strengthen the existing adult protective framework. This bill will allow the government social services to intervene, assist, and protect vulnerable adults when social work-based family and community interventions are inadequate. It will complement other existing laws that protect vulnerable individuals, such as the Women's Charter and the Mental Capacity Act. We hope to achieve two objectives. First, we want to ensure that we have the ability to move quickly to protect and support vulnerable adults as well as their caregivers when the need arises. And second, we want the protection for vulnerable adults to be effective. In drawing up this bill, we consulted our community partners and public agencies. Together, we reviewed cases where vulnerable adults were abused, neglected, or self-neglected themselves, and discussed how best to calibrate the powers that the bill should have. This was an important exercise that we did not want to rush, as we should not be excessively intruding into the sanctity of the home and eroding the autonomy and responsibility of family. During our consultations, we received strong support for the bill. I met our community partners earlier this year when the draft bill was finalized, and I was encouraged by the continued support. I would like to thank all stakeholders who provided valuable insight. We have studied these views carefully and incorporated them into the bill where appropriate. Before I go into the main provisions of the bill, I would like to assure members that the bill does not and must not replace the social work that supports vulnerable adults and their caregivers. Social work intervention is and remains the main form of external intervention in such cases. This bill, if passed by members, should be a law of last resort. State intervention through the exercise of statutory power into the family for family matters will be applied judiciously and only when necessary. This is because personal care arrangements are largely matters for individuals and families to decide on. This bill does not seek to supplant or diminish the role of the family and community. Sir, let me now bring the House through the main features of the bill, which fall broadly into four categories. And members may refer to that sheet that I passed around, which gives a broad summary of the rest of my presentation. So I hope it's useful. So 4 categories. First, the scope of the bill and guiding principles that underlie our intervention. Second, MSF's ability to intervene and protect vulnerable adults. Third, I'll talk about court orders that will enhance the protection and support for vulnerable adults and their caregivers. And fourth, I'll talk about community involvement in protecting vulnerable adults. I'll start with the first, which is the scope of the bill. First, the bill protects vulnerable adults and explicitly sets out the guiding principles underlying state intervention. Clause 2 of the bill defines a vulnerable adult as an individual aged 18 or older who, because of mental or physical infirmity, disability, or incapacity, is incapable of protecting himself from abuse, neglect, or self-neglect. For individuals above the age of 16 but below 18, we are looking to amend the Children and Young Persons Act of CYPA to extend statutory protection under the realm of the Child Protective Services, which is the sister agency of APS. Since its formation in 2015, MSF's Adult Protection Service, or APS, has seen a range of vulnerable adult cases involving abuse and neglect. Abuse under the bill refers to physical, emotional, or psychological abuse. Abuse also includes any conduct or behavior which causes an individual to fear for his safety or well-being, or unreasonably deprives or threatens to unreasonably deprive him of his liberty of movement or well-being. Hence, an individual who excessively controls another individual's day-to-day life and social relationships, and as a result causes the individual to suffer adverse emotional health effects, may be regarded as having abused that individual. A vulnerable adult may also require protection if he has been neglected. Neglect refers to the lack of provision of essential care to an individual to the extent of causing or being reasonably likely to cause injury or pain. Not providing food, clothing, medical aid, lodging, supervision, and other necessities of life are examples of neglect. A vulnerable person or a vulnerable adult may also neglect himself. Self-neglect refers to the failure of an individual to perform essential tasks of daily living, such as eating, drinking, and seeking medical aid. Vulnerable adults may, as a result of self-neglect, live in grossly unsanitary or hazardous conditions, suffer from malnutrition or dehydration, or suffer from untreated physical or mental illness or injury. Since 2015, APS has seen close to 50 cases of such self-neglect. Many do not have families to care for them. Take Mr. Wong, for example. Mr. Wong is an 85-year-old elderly man who lives alone. Again, not his real name. He has diabetes and has developed diabetic-related wounds on his feet. When community workers found him, he had not bathed for months. He did not keep his medical appointments despite running out of medication and was not able to take care of the wounds on his feet. As a result, maggots had infested the wounds on his leg and he required urgent hospitalization. But despite repeated engagements by community workers and by our social workers, Mr. Wong refused to be admitted to a nursing home or a hospital. MSF persisted and found his stepdaughter. Together, they persuaded him to accept medical care in his home, after getting assurances that his leg would not be amputated. APS also managed to get help from Mr. Wong to manage his swollen legs and to monitor his condition. As of today, nursing staff from a social service agency visit Mr. Wong weekly to clean his wound, and this has reduced the stench of rotting flesh from his right leg. 3 meals are delivered daily to him. Each week, staff from our senior activity center visit him. They also arrange for a doctor to see him whenever necessary. Mr. Wong's stepdaughter also plays a part, dividing her time between work, her own family and children, and looking after Mr. Wong. We are supporting her with caregiver support to help her cope. Cases like Mr. Wong's highlight the need for adult protection legislation that will allow government social services with powers to better support these vulnerable adults. When drafting the proposed definitions, we wanted to ensure that the bill complements but does not supplant existing laws and support networks. Certain scenarios are therefore not covered. For example, an individual who is physically abused by a family member but who is capable of protecting himself, in other words, he does not meet the vulnerability threshold under the bill, may instead apply for a personal protection order or PPO under the Women's Charter. Individuals with suspected mental illness who are not vulnerable adults may also be assisted under the Mental Health Care and Treatment Act, or MHCTA, if their behavior places them at risk of harm. Next, Clause 4 of the bill sets out the 5 key principles that guide how we will exercise and carry out the duties or exercise the powers under this bill. The powers of the bill are intrusive into the family and hence must be exercised within limits and with the right intent. We have therefore embedded these key principles in the bill to balance the need to protect the vulnerable adult with his right to autonomy and self-determination. So what are these key principles? First, when we exercise the powers to perform the duties under the bill, it must be to protect vulnerable adults from abuse, neglect, and self-neglect. The bill is not intended to solve community disputes, nor remove persons from their homes just because they may be perceived by their family members or by neighbors to be a nuisance. We will intervene if we assess that doing so is the only way to protect the vulnerable adult. That's first. Second, we recognize that a vulnerable adult with mental capacity is generally best placed to decide how he wishes to live and whether or not to accept any assistance. The bill does not seek to override an individual's freedom of choice nor coerce individuals to behave in a certain manner. MSF will seek an individual's consent before intervening. Having said that, there may be circumstances where we should intervene even though the vulnerable adult has mental capacity and refuses to accept protection. Such intervention will only take place in extreme cases involving the safety and protection of the vulnerable adult. Third, we must consider the previously expressed views, wishes, feelings, values, and beliefs of a vulnerable adult who lacks mental capacity where reasonably ascertainable. MSF will, as far as possible, respect an individual's choices and beliefs when we intervene. Fourth, we must intervene and assist in a manner that is less restrictive of the vulnerable adult's rights and freedoms of action. In order to do this, MSF will work closely with the vulnerable adult and involve his family and caregivers where possible. Fifth, the welfare and best interests of the vulnerable adult must be the paramount and first consideration. So I'll now move on to MSF's ability to intervene and protect vulnerable adults. The next category of provisions set out the state's powers. Cases such as Mr. Wong, which I referred to earlier, illustrate why it is crucial for MSF to have powers to enter private premises, assess, and if necessary, remove a vulnerable adult. The bill will only be effective if it allows us to intervene quickly to prevent further harm to the vulnerable adult. So Part 2, Division 1 of the bill empowers MSF to enter private premises to assess a person whom we suspect to be a vulnerable adult, if we have reason to believe that the individual has suffered from, is suffering, or is at risk of abuse, neglect, or self-neglect. In severe cases, the vulnerable adult may no longer be safe within his place of residence or home. Under clauses 10 and 11, MSF may remove vulnerable adults from their residence and commit them to gazetted care facilities or to the care of a fit person. This allows swift assistance to be rendered to the vulnerable adult while other care arrangements are worked out. MSF must apply for a court order within 14 days after the removal, unless the vulnerable adult is earlier permitted to return to his residence. This requirement was included because we recognize that placement can significantly impact the vulnerable adult's way of life. I wish to assure members that committals to these care facilities will only be done as a last resort for an appropriate duration until the vulnerable adult can be safely reunited with family. To ensure the vulnerable adult's well-being and safeguard his health, MSF may require him to be treated by a registered medical practitioner or registered dentist before or during his stay in these care facilities. Once committed to a care facility, the vulnerable adults must be protected from further harm. So Clause 19 requires the care facilities to undertake security measures to ensure the safety and protection of the vulnerable adults residing within their premises. While Clause 20 empowers MSF to establish a review board to ensure that proper care plans are in place for the vulnerable adult. The review board will also advise MSF on whether a vulnerable adult can be discharged within the period of committal, when the period of committal ends. By and large, the bill is premised on the vulnerable adult's autonomy to make his own decisions. That said, our experience working with vulnerable adults is that there are exceptional circumstances where we may have to intervene to ensure his safety despite his refusal to consent to intervention. This includes instances where the vulnerable adult refuses to consent to assistance because he is under duress or undue influence. Clauses 7 and 10 will therefore allow MSF to apply for a court order to assess and commit a vulnerable adult to a care facility where a vulnerable adult with mental capacity refuses assistance. Let me explain our considerations for this. First, during our consultations, some stakeholders highlighted actual cases where they were unable to help a vulnerable adult because he refused to accept their assistance. Some of these adults were abused or neglected till the day they died. Second, we looked at other countries which have longer experience with vulnerable adult legislation. Some of these jurisdictions have laws that allow a vulnerable adult's stated wishes to be overridden. For example, in Scotland, the Adult Support and Protection Act permits the state to intervene despite a vulnerable adult's refusal to consent if there is evidence that the adult is unduly pressurized and there are no other reasonable steps that can be taken to prevent further harm to that adult. Similarly, in British Columbia, Canada, the state can intervene without the vulnerable adult's agreement to remove an adult, provide them with emergency health care, and take any other emergency measures necessary to protect the adult if he is suffering from abuse or neglect. The state can do this if it is of the view that it is necessary to act without delay in order to preserve the life of the adult, prevent serious physical or mental harm to the adult, or protect the adult's property from significant damage or loss. Like the adult protection laws in these countries, our bill will similarly allow MSF to intervene despite a vulnerable adult's wishes if it is necessary to protect him and ensure his safety. But as a safeguard, we will get a court order to do so. Ensuring the vulnerable adult's welfare and best interests is paramount. However, we must also hold abusers accountable for their actions if they are culpable. Clauses 26 to 29 empower MSF to investigate offences under the bill. And to deter people from harming vulnerable adults, Clauses 40 and 41 make related amendments to the Penal Code and Protection of Harassment Act, respectively, to enhance the maximum penalties of specific offences by up to 1.5 times if these acts are committed against a vulnerable adult. This aligns with the enhanced penalties for Penal Code offences against domestic workers who are also a vulnerable group. Clause 42 also amends the Women's Charter to enhance the penalties for breaches of Women's Charter protection orders or PPOs to maintain parity with the bill. These enhancements received strong support during consultation. I will now move on to the orders that the court may make to protect vulnerable adults and support their caregivers. Clause 14 empowers the family justice courts to make intervention orders to protect vulnerable adults from further harm. The need to apply for a court order serves as a safeguard against excessive statutory intervention. When considering whether to make orders and what orders to make, the court must have regard to the same 5 principles in the bill that I articulated earlier. but it may also take into account any other relevant matters it deems fit. There are three categories of court orders. First, core protection orders. These core protection orders protect the vulnerable adult from any third party who may cause him to suffer from abuse or neglect. It includes restraining orders, exclusive occupation orders, and orders prohibiting a person from visiting or communicating with the vulnerable adult. Second, alternative placement and supervision orders. And what are these? These orders ensure that the vulnerable adult is relocated to a safe environment. The court may order a vulnerable adult to be committed to a care facility for a specified period of time, or order that the vulnerable adult be placed under the supervision of an appointed person. This appointed person may include a protector or an approved welfare officer. Third, the court can also make other protection and intervention orders, including orders to make the vulnerable adult's residence a safe living environment, and an order requiring the vulnerable adult or any other person to attend counseling or any such programs as directed by the court. This includes the power to order a vulnerable adult or any other person, including a caregiver who may have caused the abuse or neglect, to go for counseling or training and get additional support. Some vulnerable adults may face difficulties applying for such court orders on their own. So Clause 12 allows approved welfare officers to apply for core protection orders. More importantly, Clause 12 preserves the role of the family, as it also empowers family members, including a vulnerable adult's donee or deputy, to apply for protection orders. Now, by donee, I refer to a person who has been appointed by the vulnerable adult under a lasting power of attorney or LPA to make decisions on his behalf for his personal welfare, property and financial affairs if and when he loses mental capacity. And by deputy, I refer to a person appointed by the court to make such decisions on the vulnerable adult's behalf if he no longer has mental capacity to decide for himself and did not make an LPA earlier. Our aim is to help every vulnerable adult return to the love and care of his family eventually. So I'd like to come back and talk about Sam, that 29-year-old young man whose father had hit him in order to control his behavior. The bill, if members support it, will allow Sam to be placed in a care facility where he will receive the support necessary for him to manage his condition and recover from physical abuse. Having Sam temporarily away from his home may also provide respite for Sam's parents. MSF can then continue to engage Sam's father and ask that he attend therapy and counseling sessions to help him better understand and care for Sam. And if he refuses, we can try to apply to court for an order requiring him to go for such counseling or programs that the court deems necessary as an added push. The bill allows us to calibrate the level of intervention necessary for each case through a combination of statutory orders as well as social work interventions. This complements our existing adult protection system, which seeks to support both the vulnerable adult as well as their family and caregivers. Finally, I will now explain how the bill enables our wider community to play a bigger role in preventing family violence and the abuse and neglect of vulnerable adults. Members will recall the sad and tragic case of Miss Annie E. Miss E was a 26-year-old intellectually disabled waitress who left home because she wanted to work and be independent. She stayed with people whom she believed were friends. Fortunately, she was severely abused by her flatmates and eventually passed away. This was a horrible and tragic case. While the bill will allow the state to step in to protect individuals like Ms. E, none of the intervention powers in this bill will be meaningful unless those who meet and interact or come across with vulnerable individuals like Ms. E step forward and raise alarm bells for community agencies and the authorities to intervene. For example, in the case of Madam Chua, in the first example I gave, her neighbors saw bruises on her arm and around her eyes and promptly sounded the alert. Our FSCs were therefore able to inquire about the circumstances, alert us, and take action. We have therefore included clauses in the bill to strengthen the roles of both the family and the community. Specifically, Clause 23 protects people who report such cases to the relevant authorities. These whistleblowers will be protected from civil and criminal liability as long as they acted with reasonable care and in good faith. They will also not be regarded to have breached any professional etiquette or ethics. This will protect professionals such as doctors, counselors, lawyers, and so on. Clause 22 also places restrictions on the publication of information identifying a vulnerable adult. Any information that may lead to the identification of a vulnerable adult cannot be published or broadcasted. This is to safeguard a vulnerable adult's privacy and allow him to recover. This privacy will also allow the vulnerable adult and family to focus on repairing their relationship. That said, Clause 24 allows the disclosure of confidential information relating to a vulnerable adult to MSF and by us to any other government agency, statutory body, police officer, or prescribed person or body. This would include MSF's community partners, such as our Family Violence Specialist Centres, FVSCs, and Family Service Centres, FSCs, as well as medical and healthcare professionals. This is to ensure that swift action can be taken by different agencies to protect the vulnerable adult, hold perpetrators accountable, and ensure that appropriate assistance is provided to their families. MSF recognizes that working with vulnerable adults sometimes requires the making of difficult professional judgments. If we want those who work with vulnerable adults to carry out their duties diligently and professionally, we must provide them with peace of mind. So Clause 34 protects anyone performing a function or exercising powers under the Vulnerable Adults Bill from legal liability, so long as they have acted in good faith and with reasonable care. Such protection is extended to any member of the review board, any person appointed by court, and any person working in the care facilities. However, protection will only be afforded if they acted professionally and responsibly. Mr. Speaker, allow me to say something about the bill in Mandarin. 我国人口正在急速老龄化，到了2030年，每4人当中就有1人年纪在65岁或以上。随着人口结构改变，更多人，包括他们的看护者，都会年华老去。成年人遭受虐待、疏于照顾或是自我糟蹋的现象将会越来越普遍。制定弱势成人法令，就是为了保护生活在我们周遭的成年弱势群体。在新法令下，当看护者没有照顾好这些家人，有关当局有权介入，委任适当的家庭成员负起这个责任。家属也可以申请停令，阻止任何蓄意加害者接近弱势家人，以便更好地保护他们的安全。揭发或举报蓄意伤害弱势成人的事件，或挺身而出帮助弱势成人的人士，将无需承担法律的责任。任何出自善意而采取行动的社会人士，也都会受到这项法令的保护。这包括专业人士、家庭成员、左邻右舍或者公众人士等等。社会家庭发展部只有在万不得已之下，才会干预保护弱势成人。在家庭无法自行解决，社会介入也无计可施的情况下，社会家庭发展部人员有权进入弱势成人的住所，评估各方面的状况，再把这位弱势者重新安顿在安全的地方。法律也会加强管制，对任何欺凌弱势成人的罪行施以严重的惩罚，以制止弱势者受虐待或疏于照顾的行为。议长先生，我们深切了解看护家中弱势者并不容易，有时候确实会让看护者 不胜负荷。我们要告诉这些看护者的是，你们不必孤独，你们并不孤独，我们理解你们所面对的压力和挑战。社区伙伴如家庭服务中心会适时提供援助，当你们的后盾。这些社区伙伴会根据个别家庭的需求，在必要时提供辅导和支持，也可以帮助个别家庭联系互联中心，那就是 AIC， 或残障者自立局 SG Enable， 让家中有弱势成人或行动不良者能从这些机构提供的日间福利的护理或家庭服务受惠。看护者也可以善用这些暂托护理服务，给自己一个喘息的空间。要更好地照顾我们挚爱的家人，就必须先把自己照顾好，千万别让自己不胜负荷而崩溃，以致无心伤害了所爱的亲人。向周遭需要帮助的人伸出援手的同时，也要懂得在自己需要帮助的时候尽早求助。议长先生，让我现在以英语总结我的发言。Mr. Speaker, sir, the bill will only be effective if each and every one of us in the community continues to play our part. We must look out for the safety of vulnerable people and extend warmth and a helping hand to families who care for their vulnerable family members. But the abuse and neglect of vulnerable adults is not a private matter and must not be tolerated. Everyone, including family members, neighbors, community leaders, employers and healthcare professionals, have a role to play to prevent vulnerable people from being abused and to stop it if it happens. So let's step forward to break the silence by reporting suspected cases of abuse, neglect and self-neglect. Beyond the bill, MSF will continue to facilitate the community's efforts in reaching out to vulnerable adults. We will reinforce our existing help networks, such as our social service officers' local networks and the Community Network for Seniors program, to better reach out to vulnerable adults and their caregivers. Even as we operationalize the bill, we will continue to work with families, professionals and volunteers to strengthen the care networks across the community. Together, we can all do our part to keep an eye out for the most vulnerable members of our society. Mr. Speaker, I beg to move.